question, I'm sorry, I apologize if you already covered this, but how do you escalate if there's no response to the request? So not denial, not more time, any of that, but just hasn't been responded to.
Yeah, that just happened to me.
Yeah, you have to make sure they received it.
Yeah, and you do that.
How do you do it?
No, and you do that.
Well, there comes a point where they're just ignoring you.
Right.
I understand that. What that point is a judgment call. I know some folks, they'll bring a lawsuit, quickly, or they'll bring a GRC case quickly. I think you have to make numerous attempts.
Right.
My view is if the request is really important and you're having a problem getting a response, send it in by certified mail with a green return receipt card and have them sign it. Not have them, the post office has them sign it. But use that so you have the signed document that shows they received it. In my practice, it's important that we get actual denials. Because the judges, my experience with the judges, they'll say something like, look, Mr. Luers, you say they didn't respond to you. Why didn't you just pick up the phone and call them?
Right. And you do all of that.
Well, like I said, it depends on each individual case. I've waited months. I filed a case against the New Brunswick Housing Authority. I filed the case, I think it was late February, on requests going back to November. Because what was happening was the authority was telling my client, we'll get it to you, we'll get it to you. But then they didn't get it, and the date would go by, and then we'd reach out to them, or the client would reach out to them and say, oh, we're sorry, we need more time. And that would keep happening. The problem is, and I think I said that, actually I might have said this, it's okay, I might have said this before you.
That's why I apologize.
No, it's fine, it's worth emphasizing. If a public agency says, we're working on it, a judge will probably not interpret that as a denial of access. Now, I filed my lawsuit because we're working on it turned into 4 months of we're working on it.
Right.
And then the client was filing additional OPRA requests, and the new OPRA requests were getting put in the same place as the old OPRA requests, which is, wasn't getting anything. So by the time we had our third set of OPRA requests, where they're like, we'll get back to you, I said, okay, fine, enough of it. But that was 4 months. Because in my practice, I like to present sort of substantive disputes to the judges. Judges don't want to see miscommunications. Like, look, why don't you just, definitely in this county, but in most counties, the OPRA judges will say, just pick up the phone, try to work it out. If you told me that, well, it's been 30 days, I would say keep trying. Maybe as long as 60 days. Because it might be your clerks, getting internal resistance. Maybe the clerk's having a problem with someone. But like I said, it is a judgment call.
So if the clerk says, I'm inundated, and this is something that goes back until last May, and I can't get to it, I can't
Last May?
Last May.
Well, that's too long. I'll tell you right now, the year's too long.
Go ahead and do whatever, and they'll fine me $1,000. And I don't want the clerk to get fined $1,000, what that may be. But
Okay.
So really, your only alternative is GRC or a lawsuit.
Your only alternative is GRC or lawsuit. Importantly, lawsuit statute of limitations is 45 days. So if you're dealing with an OPRA request where you think you want to go to court, you have to move quickly. 45 days goes by very quickly. It's 45 days from the date of the denial. Well, what if there is no denial? Well, it's 45 days from the 7th business day when they should have responded. Now, like I said, and I do this for all my clients, if I have it's called a deemed denial. I'll tell my clients, or I'll do it myself, I'll do a follow-up. And a lot of times, if the follow-up comes from me, magically, the stuff comes out of the woodwork, because they know we're serious about, filing. Now, with GRC, there's no statute of limitations. Now, I don't agree with that rule. I think that's unfair to records custodians, but that's the GRC's rule, and until the legislature changes the law, there is no statute of limitations for a Government Records Council case. So essentially, for the GRC, the statute of limitations is really the retention period for the document. So if you have a document that they have to hold on to for 7 years, well, file by the end of the 7 years, file before they destroy the document. Because once they destroy the document, that's a defense. legally. If they it's like what we talked about. If they destroy the document legally or illegally, it's a defense to a denial of access.